Hi guys, I hope you all are doing great. So today we are here to discuss your CA Intermediate Syllabus's Other Laws, Chapter number 1, the General Clause Act 1897. So the General Clause, like from the word you can identify, general means overall, right? Which is going to give you a general overview of particular things. So in this particular chapter, what are we going to learn? Why this General Clauses Act was made, right? A basic hint which I could give you about why this was made, like if you don't find any interpretation of law anywhere else, you can refer to this act. Any words definition you don't find in the law, you can refer to this act undoubtedly, right? That is why General Clauses Act was made. That's a basic definition of purpose, right? We'll understand about legislation, we'll know what general definitions are there, we'll understand the general rules of construction and powers orders given under every enactment, right? And we'll also gain knowledge about some miscellaneous provisions, like they're not related to specific acts, but overall if you need in any of the act it is not mentioned, you can always refer to the General Clauses Act. Okay, so this chapter is divided into few parts, right? Six parts it's divided. First talks about your preliminary section number 1, then we have general definition section 3 to 4a, then we have your general rules of construction 5 to 13, how the framing is to be done of the law regulation. Powers and functionaries is given in section 14 to 19, and provisions as to orders, rules, etc. made under enactments is provided in section 20 to 24, and your miscellaneous provisions will be available in section 25 to 30, right? So if I ask you, like, why should we be learning about General Clauses Act, what will be your answer? Like, why we need to know about General Clauses Act? Right, so you may say that, ma'am, as you explained, that certain terms and principles are not defined anywhere else, so we can refer this act, right? That is the purpose this act was made. So you are learning about General Clauses Act 1897, but it was an extension, or you could say, like, it consolidated the other General Clauses Act, which was 1868 and 1887. Okay, and this General Clauses Act 1897 contains definitions of certain terms and general principles of interpretation. Okay, so this thing you need to remember, like it contains definition of certain terms and general principles of interpretation. General definitions provided are applicable to all central acts and regulations. Whatever center has prepared acts, regulations, rules they have prepared, in the absence of definition of a particular word, you can always refer to this act, General Clauses Act 1897, right? Particular word in any central act or regulation, unless there is anything repugnant in the subject or context, unless they have given something or the meaning can change as per the literal terms or etc., you can always come back and refer to the General Clauses Act 1897. Okay, I hope we are clear till here. Great. The General Clauses Act 1897 also comes for a rescue. I told you this is going to save you where nothing is written. In the absence of clear definition in the specific enactments, and where there is a conflict between pre-constitutional laws and post-constitutional laws. You know, our constitution was prepared on 26th of January, it came into effect. Right? So before this, what laws were there? If there is a conflict between them and the post-constitutional laws, that time you can always refer this General Clauses Act 1897, right? The act gives a clear suggestion for the conflicting provisions and differentiates the legislations according to the commencement and enforcement to avoid uncertainty. So if you have any conflicts between pre and post constitutional laws, you can refer to general constitutional laws, and it will help you, give you a clear suggestion about the conflicting provisions, which provision will prevail and what is to be done. All these things they will help you to understand. Okay, and differentiate the legislation according to commencement, what was commenced first, what came back down later. So all these things will be interpreted and be helped to you, okay, through the General Clauses Act. I hope we are clear till here. Great, let's go ahead. Yeah, so for example, they have given you example where the law provides that court will have the power to appoint, suspend or remove a receiver. The legislature simply enacted that whenever convenient, the court may appoint receiver, and it was implied within that language that it may also remove or suspend. Now, here what was given earlier, where the law provides that court will have the power to appoint, suspend, or remove a receiver. Person who is going to receive the money, or whosoever is entitled to money, court has the power to appoint it. Law is written in that way. Court has the power to appoint, suspend or remove. Three things were written. What are the powers of court? To appoint, then remove or suspend. Now, the legislature simply enacted that wherever convenient, the court may appoint receiver. What they have used over here, only appoint is receiver. But with the word appoint, it is implied, or it is by default, we consider that remove and suspend also powers are given to the court. Right, so powers are court, the powers of court where in like dispute over here between Ramarayan Appan versus Madhavi Amma. Okay, in that particular case, it was said that this particular person, like court has the power only to appoint as per legislature, but then they said in law it is written court has power to appoint, and it is silent or it is implied that along with appointment of a receiver, court also has a power to suspend or to remove a receiver. I hope we are clear till here. Great, that was your point number one. Okay, I hope you're understanding. Yeah. Okay, let's go ahead. That is next, object, purpose and importance of the General Clauses Act. The objective of the act are several, like there are many objectives. To shorten the language of central acts, because in every central act, if we will be writing everything, every language and every particular term, then all the acts will be very lengthy. So what they did, combine all the general things that are applicable on all the central acts, put it in the General Clauses Act. Clear? To provide as far as possible for uniformity in expression and central acts by giving definition of a series of terms in common use. I told you, like some word may be used again and again. If we say one word is act, right? So act, if I define in General Clauses Act, then all the acts will refer this act only, na? Like the definition. Instead of act, I will take word as, let's say, court is defined in General Clauses Act. Now, if I am into GST Act, if I am into Income Tax Act, or if I am into Companies Act, right? Now, again, they will give the definition of court. No, they will not give, because they will say go and refer the definition given in the General Clauses Act. Okay, because in every act, if with they put all these definitions and all, the pages will be lengthy for the laws, and whenever we have a subject, you know how ICS syllabus is there, so we will have to study that particular thing again. Why do we remember this definition? It is given in General Clauses Act. In CA intermediate we'll learn. We don't have to learn in CA foundation, we don't have to learn in CA finals, right? Here we are going to learn general clauses once for all, right, in this particular subject only. Then what will happen if they have not defined? In every subject you'll have to learn the definition is going to be same. It is of common use, na? Court is the same definition for everyone. Clear? Great, let's go ahead. Now, to state explicitly certain convenient rules for the construction and interpretation of central acts. It will also help, this General Clauses Act also helps how to interpret the law, how to frame the wordings of the law, how to construct the sentences, how to construct the provisions of law, right? So it becomes convenient what rules one need to keep in mind while you're framing the laws. I hope you might have seen that movie, Article 370, or if you have heard about it. So while they were interpreting the laws, etc., it is convenient for them now to refer the General Clauses Act, because the wordings, whatever they are framing, should be kept in mind, right? So if you want to know about convenient rules, or if you want to know about rules for how to frame the provision, you have to come to General Clauses Act, because in every act the construction should be more or less same, like the manner of construction of the laws should be more or less same. Okay, to guard against slips and oversights by importing into every act certain common form clauses which otherwise ought to be inserted in every single act. To guard against slips and oversights, like you should not miss those particular things, you should not skip those things. That's why they have put certain things or certain common clauses in your General Clauses Act. Okay, I hope the 4 points of objectives are clear. They can just ask you this as a question. It's a very easy question that you need to answer. Great. The general sorry, the General Clauses Act thus makes provisions as to construction of general acts and other laws for all India applications right? For all India application, anywhere in India you want to make a law, you can refer to general clauses law, because what will happen here, they will give you a very good insight of like how you need to frame the laws, what all things you need to keep in mind, what are the rules, etc. Right now, its importance, therefore, in point of number of enactments to which it applies is obvious. Now we can understand how important General Clauses Act is, because everywhere you will be seeing that General Clauses Act is required. Right? Great. Let's go ahead. Now, the purpose of the Act has been stated by the Supreme Court in the case of Chief Inspector of Mines versus Karam. Let's see what the purpose they have said. Okay, sorry. To place in one single statute different provisions as regards interpretation of words and legal practices which would otherwise have to be specified separately in many different acts and regulations. So this purpose of the General Clauses Act was to define them like in a common purpose, different provisions as regards to interpretation of words. Now I told you quote, that's a simple word, but everyone should not interpret it differently. Everyone should have one common interpretation. That's why they have put it over here in the General Clauses Act, because they know now everyone will think, oh, court means Supreme Court or High Court. Everyone will think. Now we have a list of courts. You have to see where you fit in that court. You have to go and refer, right? If there is some murder case, right, and the murder involved is of a particular region, so you will reach the particular region's local court, magistrate court, right? That is how the things work. That's why your legal provisions under interpretation of words and legal principles which would otherwise have to be specified separately everywhere, that is what we have clubbed together, and that is why this General Clauses Act 1897 was made, right? It stated that the purpose of this act is to place in one single statute different provisions as regards to interpretation of words and legal principles which would otherwise have to be specified separately in many different acts and regulations, because there are so many rules, acts and regulation. Environmental laws are there, taxation laws are there, then you have your family laws are there, a Hindu act, Muslim act, then your different schools of law, etc. Many things are there, many laws are there. So it is not possible now for a human being to write everywhere all these particular things. So what they said, don't write it everywhere, just club it once and do it, right? The purpose of the act is to avoid superfluity of language in statutes wherever it is possible to do so. So wherever we can just make the language common or easily understandable to people, that we have to do. Now we have to easify the or what you call it, we have to make work easy for people to understand law, because law is something very difficult to understand. Lawyers like us who have all this knowledge and who have good at interpreting the law, they only get to do it. And that also, like there are some places where lawyers may also go wrong, they may also interpret it not properly, some provisions may be hidden or there may be loopholes. So all this blend should not be there, there should not be many problems being faced by everyone. That is why what they did is they made the General Clauses Act so that people will have an ease of work. Okay, so whatever General Clauses Act says, whether as regards to meaning of words or as regards to legal principles, has to be read with every statute, every law to which it applies. So wherever court definition applies, you will have to sorry. Example number 2 talks about claim of the right to catch fish came under the consideration of court in Ananda Behra versus State of Odisha. The court tended to decide whether the right to catch or carry fish is a movable or immovable property. So here you see there are two major terms that they are talking about, that is movable or immovable property. So now we will have to interpret over here, is this property a movable property or not, right? Now let's go ahead with this. Sorry for the view. Yeah, I hope it's clear now. So as stated over here, section 326 of the General Clauses Act 1897 read as under, immovable property shall include land, benefits to arise out of land, and things attached to earth or permanently fastened to anything attached to it. Now tell me, like, right to catch a fish, is it a movable or immovable property? Is it associated with land? Benefits arising out of land, that things we have to interpret now. Section 3 of Transfer of Property Act does not define the term except to say that immovable property does not include standing timber, growing crops or grass. As fish do not come under the category of definition of General Clauses Act applies, and as the profit as spent rate is regarded as a benefit arising out of land, it follows that it is immovable property within the meaning of Transfer of Property Act. Why we are using this? Because they said that the term like transfer of property does not define the term except to say that immovable property will not include what it will not include: standing timber, growing crops or grass. These three things are not included in immovable property. So whatever we are transferring other than that, that will become immovable property. That is why catching of fish is also as good as arising benefits arising out of land, right? Because on land only there will be water, and from that only you'll be catching the fish, right? And also in the exceptions of Transfer of Property Act, they have not written, like they have not defined Transfer of Property Act, but they have given certain exceptions, like this is not immovable property. What are those exceptions? Standing timber, growing crops or grass. Now in this nothing is written about the fish that we catch, right? So that is why we'll consider this as immovable property. Thus, the court construed right to catch or carry fish as an immovable property. Court has given the title of catching the fish as immovable property. Okay, great. Application of general clauses. The Act does not define any territorial extent, to what extent this clause will apply or what not. Its application is primarily with reference to all central legislation and also to rules and regulations made under the Central Act. It is in a sense a part of every central act or regulation. If a central act is extended to any territory, General Clauses Act would also deem to be applicable in that territory and would apply in the construction of that central act. Central Act uh, acts to which this act apply are Acts of Indian Parliament Central Act along with rules and regulations made under Central Act, Acts of Dominion Legislature passed between 15th August 1947 to 26th January 1950, from the date of independence till the drafting of our constitution. Okay. Now see what they have said over here, that this General Clauses Act will apply to every act that you make in the central laws or whatever regulations you make. If in particular state or in particular territory this law is made, suppose we make a law for Jammu and Kashmir, or we make a law for Chandigarh, Punjab. So these laws whatever you are making, General Clauses Act will also be applicable till here. If you are making some laws for the union territory, so there also your General Clauses Act will apply. Okay, I hope we are clear till here. Great. Now what they said, pendre is a French word, if I am not wrong, where it went. Yeah, see it was written over here. And as a profit a pendre. Now let's see what profit as a pendre means. French, right of taking, the right of person to share in the land owned by other. A profit pendre enables a person to take part of the soil or produce of land that someone owns. So if someone is owning some land, you can also gain the benefits. If you have that part of lake where you have the rights and permissions to do fishing, you can get all the fishes out of it, and that all will be yours, right? Fishers also need a license etc for fishing over a particular land. I hope this is clear. Sorry for the sudden jump in the pages. Yeah, okay. Now, also what they have said, that your general clauses will be applicable to Indian Parliament enacted rules and regulations, whatever laws they make under the Central Act. Then, Dominion Legislature passed between 15th August to 1947 and 26th January 1950. I told you, between this transition period where we got the independence and the day when the Constitution came, was being made applicable, between that period also whatever laws were made, acts were made, all this will include General Clauses Act interpretation also. Wherever they need General Clauses Act help, they will be taking it from there. Okay, I hope it is clear. Third, what they have said, Acts passed before the commencement of constitution by the governor general in council or the governor general acting in a legislative capacity. The act does not define any territorial extent of clause. Again, they have said the same thing. Whatever acts are applicable between this commencement of the constitution, like before the commencement of constitution, as I told you earlier also, not in the transition period, before getting independence also, they will also include General Clauses Act, because your General Clauses Act is applicable from 1897 while we were still under the British rule. Okay. Passed by the Governor General in Council or Governor General acting in a legislative capacity. Act does not define any territorial extent. We don't have any territorial extent. Okay. Great. One second. I'll just remove, like, make this a little less. Yeah, that is better now. So application of General Clauses Act is Act of Parliament, Act of Indian Parliament, then your Act of Dominion Legislature, and Act passed before the commencement of Constitution by the Governor. Any Act before independence also. Here you will be taking Acts of Indian Parliament, that is after Constitution. This is before Constitution, and this is 15th of August 1947 to 26th of January 1950. Transition period. Okay, Dominion legislature. I hope this is clear. They are generally telling you that General Clauses Act is applicable everywhere. From the date it was made in 1897, from that time till today, right? Article 367 of Constitution of India authorizes use of General Clauses Act for the interpretation of Constitution. Article 367 states that unless the context otherwise requires, General Clauses Act shall, subject to any adaptations and modifications that may be made herein under Article 372, apply for the interpretation of this Constitution as it applies for interpretation of an act of the legislature of the Dominion of India. So wherever in any of the act before the legislature, before the commencement of constitution by the governor, then your Dominion legislature or any act passed by Parliament, wherever required, General Clauses Act will be applicable. The provisions of it will be adapted accordingly. Okay, great. Provisions of the General Clauses Act 1897 are mere rules of interpretation, and it applies automatically in each and every case. Whatever provisions are there, they will automatically apply. Like I told you, immovable property. Where you learn about immovable property? First thing, if I tell you, you're CA Inter student, so you might have learned in your income tax, you might have learned in your GST. Then every time you see the immovable property definition, no, it is written in General Clauses Act. Learn there and come here, right? It all depends on the facts and circumstances of each case, right? What we are talking about, it will depend on that this particular thing will be included in immovable property or not. Like fish catching is included in immovable property. I talk about timber collection, so that is not included in immovable property. That is specifically exempt in Transfer of Property Act. Okay, clear? Great. In many countries, legislatures similar to General Clauses Act are called Interpretation Act. So, in many countries, they also use Interpretation Act as a word instead of General Clauses Act. But as the provisions of General Clauses Act, whether relating to definitions and meanings of words and terms or dealings with construction and interpretation, are so far as may be necessary common to every central act, the title General Clauses Act is not less appropriate than the title Interpretation Act. So, like General Clauses Act is a better name, they want to say. Supreme Court had observed in the case of Chief Inspector of Mines versus Casey Thapar, whatever the General Clauses Act says, whether as regards to meaning of words or as regards to legal principle, has to be read into every act to which it applies. So what was decided in this case of Chief Inspector of Mines versus Casey Thapar, that wherever you read the law and any meaning of words you want or any legal principles you want to know, you have to read it into the act of General Clauses Act wherever it is applicable. Okay, if in your GST Act some definition is given, so refer that only. If it is not given, go back to your General Clauses Act. Okay, The scope and effect of each section depends upon the extent of particular section. How important or what is the extent of that section, then your scope and effect will be decided. Okay, that's just a general statement you need to remember. Example, Section 3 of General Clauses Act, which deals with definitional clause applies to General Clauses Act itself to all central acts and regulations made under the commencement of the General Clauses Act in 1897. So they want to say that wherever your General Clauses Act definitions are applicable, it will apply to all central acts. Okay. Similarly, Section 4 of the General Clauses Act, which deals with application of foregoing definitions to previous enactment, applies to central acts and thereafter and after January 3rd, 1868, and the regulations made after January 1887. So I told you, like earlier, there were two other laws of the General Clauses Act that are also clubbed over here. So whatever previous enactments were there, whatever laws or regulations were applicable there, now this General Clauses Act will be applying over here. Okay, foregoing applications that are there, now whatever definition we have given in the General Clause Act 1897, that will be applicable. So there is difference in applicability of each section as regards to statute to which it applies. Where we are talking about immovable property in GST may be a different topic when we are talking about immovable property in income tax, right? Like in income tax, what may happen, you are talking about immovable property transfer, so that is with your capital asset, right? But when we are talking about immovable property in GST, then we will be thinking whether there will be taxation in purchase of immovable property or not, right? There can be different applicability of each section. The language of each section of the General Clauses Act has to be referred to ascertain to which class of instruments or enactment it applies. In certain cases, even if no section of General Clauses Act applies to a particular case, court applies the general principles of General Clauses Act. In General Clauses Act also there are many definitions, but if some specific definition is not going about property, you will refer to the general principle of the General Clauses Act, right? It may also be noted that Act also serves as a model of State General Clauses Act. It is evident that the State General Clauses Act should conform to the General Clauses Act. Not only central acts should be in conformity with General Clauses Act, they only not should take help of General Clauses Act, but State General Clauses Act also needs to be kept in mind, or they are also in conformity with the major General Clauses Act. For otherwise, divergent rules of construction and interpretation would apply, and as a result, great confusion might ensure. So, whatever is the General Clauses Act that is applicable for India should be in conformity, like other laws like Maharashtra General Clauses Act. This should be in conformity. Karnataka General Clauses Act should be in conformity, right? Then we have Gujarat General Clauses Act. This should be in conformity with your India's General Clauses Act. Otherwise, what will happen? There will be confusion, right? Then the construction of the language of your law will be different, right? There can be different meanings to one particular thing. In Maharashtra, they think this as this particular thing, and in Karnataka, they think of this thing as a particular difference. That shouldn't be there. There should be equality, right? Now, before delving into a saddle of the provisions of General Clauses Act, let's have some basic understanding of law. So now we will be understanding what is legislation, what is law. I hope you might have heard or learned about it in your CA foundation also, but there will be some like understanding given to you, basic understanding, which is relevant for you again over here to brush up your knowledge. Okay. So, basic understanding of legislation. First, you might have seen in your entire like academic career, also in your school life, etc. There is a preamble word. So, what preamble is, right? Every act has a preamble which expresses the scope, object, and purpose of this act. Right? Preamble will tell you what is the scope, what all things are being covered in this particular act, how much is the extent, what is the scope of this, and why we are writing this act, right? Why we have enacted this act. It is the main source for understanding the intention of lawmaker behind that. To why this law was made, what is the intention of lawmaker, you'll understand with this particular preamble. Then, Whenever there's ambiguity in understanding any provisions of act, preamble is accepted as an aid to construction, right? Whenever you don't understand anything, why this act was made, or if there is ambiguity, you will have to understand that preamble will help you to understand the purpose of creating this act. The preamble of a statute is a part of the enactment and can legitimately be used for construing it, for understanding it. However, preamble does not override the plain provisions of the act, but if the wording of the statute gives rise to doubts as to its proper construction, for example, where the words or phrase has more than one meaning and a doubt arises as to which of these two meanings is intended in the act, then preamble can and ought to be referred to in order to arrive at the proper construction. In short, if you want to just understand, preamble will be disclosing what is the primary intention of this legislature, but this can be only taken help with when you have the language difficulty, like I'm not understanding what is the meaning of this particular act, or any provision is not clear to you. That time you can refer it, but your preamble will be not overriding any of the provisions of the enactment. Okay, that's what is written in this paragraph also. Act discloses primary intention of legislature but can only be brought in as an aid to construction if the language of statute is not clear. If you are not able to understand what is the language of statute, that time you can take help of the preamble. However, it cannot override provisions of enactment. I told you, whatever is written in act, that will prevail. Preamble won't prevail, but whatever is the provisions written in the act, that will always prevail. Okay, I hope this is clear. Now, preamble of the Negotiable Instruments Act 1881 states an act to define and amend the law relating to promissory notes, promissory notes, bill of exchange, and check. What is written over here? Preamble of Negotiable Instrument Act is written as an act to define and amend the law relating to promissory notes, bill of exchange, and check. So we get to know what all things are done in this Negotiable Instrument Act. They will write what is promissory note, definitions will be given, bill of exchange, check, drawer, drawee, all these things will be given. If they want to amend any of the provisions, that also they can do. Okay. Preamble of the Companies Act 2013 states an act to consolidate and amend the law relating to companies, right? An act to consolidate and amend the law relating to companies. Whatever they want to do, they want to combine something, because earlier it was 1956, Companies Act 1950. Then they gave rise to then they converted it into Companies Act 2013. So any amendments they want to do, they want to consolidate any of the provisions of other acts over here, that also they can do. Okay, in order to understand preamble of act, it is important to know the act. Act is a bill passed by both the houses of parliament and assented to by the president. You might have learned this in your CA foundation also. Act is all like something that is passed, or when it is presented in both houses of parliament, then you get the approval on it, and then president signs it. You might have learned this in your school time also. Whereas bill is a draft of legislative proposal put in proper form, which when passed by both the houses of parliament and assented by the president, becomes an act. So first when you bring it, it's a piece of paper that's called as a bill. That is just your suggestion. Then it will go to both houses of parliament, Lok Sabha, Rajya Sabha, and then when both houses have given the approval, have passed it, then it will go to president. Then president will give the assent, and then only it will become. On getting assent from president, an act is notified in the official gazette of India. When you get the approval on the bill, it becomes an act, and act, when it is approved, it has to be published in the official gazette of India. Okay, I hope this is clear. Great. Now, what definitions? Every act contains certain definition part, or the for the purpose. Because you see, in GST Act also you might be having some definition. Income tax also you might be having some definition. Definition of tax collected over here, right? Who is an assessing officer? What is the role of assessing officer? All these things that will be given. But assessing officer's definition is given to, who's an individual person who is taxable, right? All these things, assessment here, that is the basic definition given also. Why it is given? So that you should be able to understand the act very nicely. Okay, let's go ahead now. Every act contains definition part for the purpose of that particular act, and that definition part are usually mentioned in section 2 of the act, but in some other acts it is also mentioned in section 3 or in other initial section. So usually what they do is now they will be putting those definitions in section 2 of the act. If not in section 2, they will be given in section 3, or like if it is going a little beyond, in section 4 5, but mostly in the initial sections of that particular. Hence, definitions are defined in the Act itself. Object of definition clause is to avoid the necessity of frequent repetitions in describing all the subject matter to which the word or expression so defined is intended to apply. Why we have definition clause over in general clauses? Because they don't want the repetition to be done. Now, if something is very clearly understandable in General Clauses Act, then you can refer only General Clauses Act once. Like I'll tell you, I am a lawyer. So when we were learning, we were asked to learn about the General Clauses Act also, because they will say that why you are going to like when I'm reading, suppose I start reading the Negotiable Instruments Act, or if I'm reading the Motor Vehicle Acts. So in Motor Vehicle Act, some definition I don't know what they have written in that book in Motor Vehicles Act. Refer this in General Clauses Act. So then after that, if I go back and refer to General Clauses Act, that will not be very helpful. First thing, prima facie, which I should be doing is I should be reading the General Clauses Act so that I know the basic definitions. That is why this definition clause is given. Okay. However, if there may be words which are not defined in the definitions of the Act, the meaning of such words may be taken from General Clauses Act 1897. Some words are not given in the Motor Vehicles Act. So what I will do? I will go back to General Clauses Act and see. Right? Words are defined in the respective act. Sometimes definitions are referred in other statutes. If words are not defined in the respective act, such words are to be taken from general clauses. The word company used in Companies Act 2013 is defined in section 220 of the respective act. Companies Act is there. They will have to give the definition of companies, right? Now, word security used in Companies Act is not defined in respective act. It has been defined under section 2H of the Securities Contract Act 1957. The word is equivalently applicable on the Companies Act because securities have a separate act, Securities Contract Act. Sorry. Yeah. Securities has a specific act, na Securities Contracts Act 1956. So you refer there. Don't come here. Similarly, the word digital signature used in Companies Act shall be construed as per section 21P of Information Technology Act 2000. So that is given in IT Act 2000, digital signature. Go and refer there, right? Clause 95 of Section 2 of Companies Act 2013 clearly states that words and expression used and not defined in this act but defined in Securities Contract Act 1956 or Securities Exchange Board Act Board of India Act, SEBI Act, or the Depositories Act 1996 shall have the meaning respectively assigned to them in those. So if not, some word is not given in Companies Act people are very clear. They will tell you if it is not written over here, now go and see the SEBI Act, go and see the Securities Contract Act, Depositories Act. There you will find the meaning, and that meaning is applicable here also. Like in the Depositories Act, they may define who is a deposit, what is a depository, who can deposit, who's a depositor. All these things they can give you definition. You go and refer there. Okay. Now, the word affidavit, you might have heard this word used in section 7 during the incorporation of company in the Companies Act shall derive its meaning from the word affidavit as defined in General Clauses Act 1897, because this definition affidavit is used everywhere. It is not just used in Companies Act. I want to write something and I want to like notify about something, like I authorize this person to stand in on my behalf in the court. I have to make an affidavit, right? If I want to do any legal matters, mostly I will need an affidavit, right? So for these things they will say where why you are going to run in every act of your whatever need is there, Companies Act, Motor Vehicle Act, Environment Act. Come here, we will write the definition in General Clauses Act, refer from there. Why you have to run everywhere? Because affidavit is used in every act, every damn act, every particular law, every particular region you want to go, you will get the affidavit thing. Okay. Now, means and or include. Some definitions use the word means, right? Such definitions are exhaustive definitions and exactly define the term. Exhaustive, they are limited. That is exact definition. It means this. And or includes means this may include more things, right? Definition of company as given in section 220 of Companies Act. It states company means a company incorporated under this act or under previous company law. They have specified company. You want to think it is only two things: company incorporated under the Companies Act 2013, company incorporated under the Companies Act 1956. That is it. No other act can write the name as company, and if they are writing it, we are not going to include that as a company in Companies Act 2013. Means exhaustive, only this much, right? We say that this particular thing I am going to share with my best friend, so you are only sharing with your best friend, one or two, right? It may be one or two, not everyone. If you want to share things with everyone, you call everyone on your birthday party, right? Your friends. But if you have any sorrow kind of a thing, you are into a very bad problem, you are going to share it with your closed friends, like your best friends, one or two only. So this is the definition, like you can understand from here the meanings and include. I'm using a relatable example so that you people be able to understand. See example 10. Section 234 of Companies Act 2013 defines the term director as director. Means a director appointed by board of company. Other person says I am a director of LLP. Can he come over here? No, that is a partner over there. Director only as appointed to the board of the company will only be included over here. Okay. Some definitions use the word include. Some definitions do not define the word but are inclusive in nature, where the word is defined to include such, and such definition is prima facie extensive. It is wide. You can also include many things. It may include more things also. The word defined is not restricted to the meaning assigned to it but has extensive meaning, which also includes the meaning assigned to it in the definition section. We'll see with an example. Word debenture defined in section 230. It says debenture include debenture stock, bonds, or any other instrument of a company evidencing a debt. Now here what happened? Debenture stock, bonds, but they use third thing also, any other instrument of a company evidencing a debt. You give a piece of paper and say this is a debt to you, that is included in debenture, right? Whether constituting a charge on the asset of company or not. It is not said that you have to compulsory give something in like as a security. It is okay when you issue the debentures, you don't give a security, right? In loan you give a security, you give a charge, but here you need not to give a security also. Body corporate or corporation includes a company incorporated outside India, right? So this will include, right? This also has a wider scope, because body corporate, your company is a body corporate, LLP is a body corporate, and your company incorporated outside India is also a body corporate. So it includes, and this can after some time, if after 3 years in 2027 they want to launch a particular law, then they want to include that particular entity as a body corporate, they will include over here, right? The above definition of body corporate does not define the term body corporate, but just states that companies incorporated outside India will also be covered under their definition of body corporate, apart from other entities which are called as body corporate. So I told you companies is there, LLPs is also there. We may also find a word being defined as means and includes such and such. Here the definition would be exhaustive. Share defined under section 284 of Companies Act. Share means the share in share capital of a company and includes stock. So here also it is exhaustive because it means share, part of share capital, like a share in the share capital, and instead of share you can also write it as stock. Same thing, share or stock, both are the same things. On the other hand, if the word is defined to apply and to include, the definition is understood as extensive. To apply and include, if these words are written, then your definition will be having a wider term. Okay, I hope this is clear. Shall and may. The word shall is used to raise a presumption of something which is mandatory or imperative, right? We shall do this, right? While the word may is used to connote something which is not mandatory, but it's only directory or enabling. However, sometimes the words may and shall can be interpreted interchangeably depending on the intention of the legislator. We'll see with an example, you'll understand. Section 3 of the Companies Act 2013 states that a company may be formed for any lawful purpose by, right? May be formed. If you want, you can form. If you don't want, you don't form it, right? Here, the word used may shall be read as shall. Usage of word may here makes it mandatory for a company for the compliance of section 3 of its formation. So if you want to make a company, you have to follow this section number 3. So a company may be formed. If you want to form a company, you shall have to comply with this provisions of section 3 of company. Okay, that is how it works. Section 21 of the Companies Act 2013 provides that documents proceeding requiring authentication or the contracts made by or on behalf of the company may be signed by any key managerial personnel or an officer of the company duly authorized on this behalf. So what they have said, made by or on behalf of company may be signed by any KMP or an officer of the company duly authorized by board. So here only two people are authorized, either the KMP or officer of company duly authorized by them. Okay, because authentication is required, so here you will have to use of word may shall be read as may only here, right? The use of word shall with respect to one matter and use of word may with respect to another matter in the same section of a statute will normally lead to the conclusion that the word shall imposes an obligation. We have learned in school also, in grammar also, shall will impose an obligation, whereas word may confers a directionary power. It is your choice. If you want, you can do it. If you don't want, you can skip that thing, right? Now, in Scenic Motors versus State of Rajasthan, J. Hidayat observed the word shall is ordinarily mandatory, but it's sometimes not so interpreted if the context or intention otherwise demands. Our approach in this text is to provide basic understanding of law while studying any legislation. Why they have given you this General Laws Act? Because you are studying so many laws now. You're studying income tax, you're studying indirect taxes, you're studying about companies. So in all these laws, when you're studying, you should be having a basic understanding. That is why this particular thing is included in your syllabus, right? So these basic things you should remember, because as we are going to be chartered accountants, right, we need to remember few things, right? You will read many topics like the following concepts in detail in the interpretation of statute also. Here an overview is given about preliminary and etc. I told you we have already discussed how this chapter is going to go ahead. So this was like an overview of General Clauses Act, what we are going to learn over here. Now we'll be starting with the preliminary section number 1. Okay, I hope we are clear till here. Yeah, so let's take a break of 2 minutes and then resume.